Good morning, everyone. Our task is to explain the sources of human rights and the international humanitarian law. Sources of international law. There are two sources, primary sources and secondary sources. So there are three belongs to primary sources. First is treaties or treaty convention, customary law or international customs, general principles or general principles of law. And in secondary sources, there are two, jurisprudence or judicial decision, literature or teaching of publicists. So my topic is treaties or treaty conventions, and others to be reported by some of my members. So treaties. Treaties are the most important source of international as they require the express consent of the parties concerned. Article 38 of the International Court of Justice gives the highest importance to the treaty while deciding to dispute, where international convention whether or particular establishing rules expressly recognized by the contesting states. International customs as evidence of a general practice accepted as law. The general principles of law recognized by civilized nations. Subject to the provision of Article 15 on judicial decisions and the teaching of the most highly qualified publicists of the various means for the determination of rules of law. These provisions shall not prejudice the power of the court to decide as a case ex eco et bono if the parties agree thereto. So, according to Article 2 of the Vienna Convention 1969, a treaty is an agreement whereby two or more states establish or seek to establish a relationship between them governed by the international law. So, there are two kinds of treaties, the law-making treaties and treaty contracts. So, what is law-making treaties? Law-making treaties, they create universal norms as they have a large number of members. They do the same work in the international field as the legislation does in the field. So, and what is treaty contracts? They create a special obligation between the parties only. They are not a source of international customary law. This focuses only about treaties. There are two principles of treaties. First is pacta sunt servanda, basis of validity of treaties. Vienna Convention on the Law of Treaties 1969. So, pacta sunt servanda. According to this principle, treaties are binding upon the parties and they must be performed in good faith. It is given under Article 26 of the Vienna Convention on the Law of the Treaties. This is possible norm of international law. This is a role of society with deep moral influence. It is a state is performed out of a revolution, then that states won't be binded by this principle. So, in Vienna Convention on the Law of Treaties 1969, on 23rd May 1969, the United Nations Conference on the Law of Treaties adopted the Vienna Convention of the Law of Treaties. As of January 2018, 116 state parties have ratified convention. Sovereign states are competent to make a treaty under the convention. Any treaty which is concluded under the threat or use of force is void. So, formation of conclusion of treaties. There are 4 rules. Rules which apply in the formation of international treaties. First is signature, ratification, accession, registration. So, what is signature? A treaty becomes authentic after the signature of representative of the states. Ratification. Ratification, unless and until the treaty is ratified, it will not bind the state. Ratification means that the head of the state conforming the constitutions of the treaty. Accession. It is a method by which a state become a party to a treaty of which it is not a signatory. Registration. Registration. Every treaty is required to be registered with the Secretary General of the United Nations. So, let's proceed to this four. First is reservation to a treaty. The term reservation is defined under Article 2 of Vienna Convention as a unilateral statement made by a state when signing, ratifying, accepting, approving, or acceding to a treaty whereby it proposed to exclude or modify the legal effect of certain provision of a treaty in their application to the state. Every state is entitled to show reservation when signing, ratifying a treaty under the reservation in prohibited by the treaty. Treaties and third states. Pacta tetris nec nocent. Under Article 34 of the Convention says that a treaty does not create either obligations or rights for a third state without its consent. Treaties bind only the parties which participate in it. However, a treaty may create rights to a third state in certain cases, where a third state accept the obligation of a treaty. Second, where a third state expressly gives assessment to the rights given from a treaty. If a treaty creates an international customs, then it will be binding even to the states who haven't given their consent. So, jus logens. Jus logens. This is Latin from, it means compelling law. So, some principles of international law cannot be altered making treaties. These rules are jus cogens. Jus cogens are peremptory norms of international law under Article 53 of the Vienna Convention. A treaty is void if at the time of its conclusion it conflicts with a peremptory norm of general international law. These rules of jus cogens exist in the common benefit of the whole international community. The rules of jus cogens aren't defined well by the convention. Rebus sic stantibus. It is a principle in customary international law which gives the power to a party of a treaty to withdraw or terminate it because of a fundamental change of circumstances. Under Article 62 of the Vienna Convention, this rule is given acceptance. Under Article 42 of the Vienna Convention, It is given that the validity of the treaty can be impeached by the rules given in the convention, which are as follows. In my topic, there are also invalidity. First is lack of proper authority of the representatives. Article 46 and 47. Error in the treaty. Article 48. Fraud committed by another party. Article 49. We already know that fraud is a crime which uses dishonest method to distract people or other person. So, corruption of the representative. Article 50. Question of representative. Article 51. Question is power or principle. Question of a state. Article 52. Jus cogens. Article 53. Jus cogens refers to certain fundamental overriding principles of international law. Jus cogens is from Latin compelling law, or in English peremptory norm. So these all articles can be seen of the Vienna Convention of the Law of Treaties. So let's proceed to termination of treaties. First is by consent, by denunciation. What is denunciation? Denunciation is the public statement that strongly criticize someone because of bad or wrong. Third is by concluding another treaty, by material breach, impossibility of performance according to provision of the treaty, by the emergence of the treaty, by fundamental change of circumstances. So these are to be reported by one of my member about customary law. So that's all. Thank you and God bless.
Good noon, everyone. My report is about the customary law and international custom. So first, we talk about the customary law. Customary law is consisting of custom that are accepted as legal requirements or obligatory rules of conduct, practice, and beliefs that are so vital and intrinsic a part of social and economic system that they are treated as they were laws. So first, there are examples of customary law. These are okay. There are examples of customary law. Covers all matters regulating personal and family life, including matter relating to children, such as care, contact, maintenance, guardianship, and initiation. So second topic is international custom. International custom is an aspect of international law involving the principles of custom along with the general principle of law, and treatise custom is considered by the International Court of Justice, juries, and United Nations and its member state to be among the primary sources of international law. So there are examples of international custom. Play ra gusto para masen siguro sen ba. So there are example of international custom. The doctrine of non-refoulement and granting of immunity of visiting heads of state. So that's all. Thank you.
So hello everyone, my name is Butch Anito. Our task is to report about the sources of international law. So today, my topic is to report the third primary source of international law. So the third source of international law is enumerated in Article 38 are General Principles of Law, recognized by civilized nations. The Guide to International Legal Research states that this traditional naturalist approach provides a basis for decision when other resources offer no guidance. It is unclear that these general principles of law are. Thus, locating these general principles in the course of legal research is extremely difficult. They could be general principles of justice, natural law, analogies to private law, principle of comparative law, or general conception of international law. Include in the list of sources of international law in Article 38 of the International Court of Justice Statute are general principle of law recognized by civilized nations. Example, in general, principles of fairness and justice which are applied in university and legal systems around the world. Examples of these general principles of law are laches, means is a defense to a proceeding in which a plaintiff seeks equitable relief. So plaintiff means the party who brings a legal actions or in whose name it is brought, as opposed to the defendant, the party who is being sued. The next one is the good faith. Good faith means in law exists even in contracts that expressly allow either party to terminate the contract for any reason. Fair dealing usually requires more than just honesty. So the next one is res judicata. Res judicata means a matter that has been adjudicated by a competent court and may not be pursued further by the same parties. And the impartiality of judges. Impartiality of judges means fairness and equality with both sides of parties. Then international tribunals rely on these principles when they cannot find authority in other sources of international law. So these general principles of law can be found in decisions of international tribunals and national courts. References to them may also be found in the teachings of the mostly high-qualified publicists. Example, eminent international law scholars. In fact, Article 38 concludes judicial decisions of both international and municipal tribunals, and scholarly writings as subsidiary means for the determination of rules of law. In other words, these are not authorities, rather they are evidence of the source of international law. So, next is the first secondary source of international law. So, the jurisprudence or the judicial decision. Case law or legal decisions which have developed and which accompany statutes in applying the law against situation of fact. Technically, jurisprudence means the science of law. Statutes articulate the bland rules of the law, with only rare reference to factual situations. The word jurisprudence derives from the Latin term jurisprudentia, which means the study, knowledge, or science of law. In the United States, jurisprudence commonly means the philosophy of law. The third type of jurisprudence seeks to reveal the historical, moral, and cultural basis of particular legal concept. The definition of jurisprudence is the legal system or the theory and practice of the law. The court and trial system used to administer law, and justice is an example of jurisprudence. The philosophy or science of law, a division, type, or particular body of law. Most of our law has been taken from common law system. So, little information. Bentham is known as father of jurisprudence. Then, Bentham was the first one to analyze what is law. He divided his study into two parts. First is the examination of law, as it is expositorial approach, means command of sovereign. The second is examination of law, as it ought to be sensorial approach, means morality law. Then suddenly, Austin took his work further. But, however, Austin stuck to the idea that law is command of sovereign. So that's all my topic for today. Thank you so much and have a good day. Okay.
Good evening, everyone. This is Jake Clinton here, and I'm assigned to report about jurisdic writings. The teachings of the most highly qualified publicists are the given same place as the judicial decisions under the secondary sources of international law. So, meaning jurisdic writings and judicial decisions are in the same place and were under in the secondary sources of international law. So, let's continue. Article 38 Statute of ICG recognizes that the teachings of the most highly qualified publicists of the various nations as a subsidiary means for the determination of rules in international law. So, this means that in order to support the rules of international law, they need to get a highly qualified publicist to support the law. So, let's continue. Writers such as Gentili, Grotius, Vatid, and etc. were the supreme authorities of the 16th and 18th centuries and determined the scope from content of international law. So, I have some examples of the given names. Full name of Gentili is Alberico Gentili, an Italian jurist, tutor of Queen Elizabeth I, and a standing advocate to the Embassy of Spanish in London. Professor of Oxford for 21 years. So, here's another one. Hugo Grotius, also known as Huig de Groot or Hugo de Groot, born in Delft and studied at Leiden University. A Dutch humanist, lawyer, diplomat, jurist, poem, and playwright. So let's continue. Diverse international, judicial, and arbitral bodies, in considering their decisions, consult and quote the writings of the teaching juristic authorities when need arises. So, judicial and arbitral bodies, if they need something to improve, they make their decision to go to the juristic authorities to consult their quote and writings if they had some mistakes, or if they have to improve something, or that's all.